The October 14th meeting of the Board of Zoning Appeals is now in session. Good evening and welcome to this meeting of the Arlington Board of Zoning Appeals, which is also known as the BZA. I am Inta Malice, Chair of the Board. The board is made up of 5 citizens appointed by the Circuit Court. In addition to myself, we have Vice Chair Peter Owen and members Judy Freshman, Paul Melnick, and Portia Clark. Also present is the professional staff, including Stephen Rizzi, coordinator for the BZA, Cliff Hogan, assistant to the zoning administrator, Mark Hamela, zoning technician, and Matt Busing, acting assistant to the zoning administrator. For the safety of our board members, county staff, applicants, and participating community members, we are a virtual meeting today, and all participants are joining remotely. We are legally authorized to hold this virtual meeting based on the governor's executive orders, legislation adopted by the Virginia General Assembly, and the Arlington County Board's Continuity of Operations Ordinance adopted in March of 2020. We thank you for being here and extend a warm welcome. Before we call our first case, I will share with you some general information about the Board of Zoning Appeals. Then I will also share some ground rules on how we will conduct this virtual meeting. The staff reports for each case on tonight's agenda can be found on the BZA website. Staff has placed a link to the agenda in the chat section of this session. If you have not yet seen the report for your case, you may wish to review it before your item is called. The board's powers are prescribed in the Code of Virginia and are set out in further detail in the county's zoning ordinance adopted by the county board. The Board of Zoning Appeals does not have the power to rezone property or to amend the regulations set forth in the ordinance. That authority rests with the county board. This board does have the authority to do 3 things. 1, we can approve use permits that allow modification of placement requirements for structures on 1 and 2 family lots where there is no option in the zoning ordinance to allow for such modifications. We can grant variances from specific requirements of the zoning ordinance. And 3, we can decide appeals of decisions of the zoning administrator. When approving use permits, the Board of Zoning Appeals may impose conditions that it deems necessary in the public interest, including limiting the duration of the use permit. In order to approve a use permit, the law requires that the board find that the proposal meets certain conditions and that the use permit will not adversely affect the health or safety of persons residing in the neighborhood, will not be detrimental to the public welfare or injurious to property improvement in the neighborhood, and will not be in conflict with the purposes of the master plans and land use and zoning related policies of the county. To do this, the BZA shall consider whether modifications will promote compatibility of development with the surrounding neighborhood because the structure's overall footprint, size, and placement are similar to structures on properties surrounding the lot in question, and whether the modification will help preserve natural landform, historical features, and/or significant trees and foliage. When granting variances, the burden of proof is on the applicant to prove by preponderance of the evidence that the improvements meet the following criteria: that the strict application of the ordinance would unreasonably restrict the utilization of the property, or that granting the variance would alleviate a hardship due to the physical condition relating to the property, or the improvements at the time of the effective date of the ordinance, or that granting of the variance would alleviate a hardship by granting a reasonable modification to a property or improvement thereon requested or on behalf of a person with a disability, and the property for which the variance is being requested was acquired in good faith and any hardship was not created by the applicant. That the variance granted will not be of substantial detriment to adjacent property and nearby properties in the proximity of the geographic area. That the condition or situation of the property concerned is not so general or reoccurring in nature as to make reasonably practical the adoption of amendment to the ordinance. That the granting of the variance will not result in a use that is not otherwise permitted on the property or change the zoning classification of the property, and that the relief or remedy obtained through the variance is not available through a special exception process as provided for under the zoning or subdivision ordinance. When deciding appeals of the zoning administrator, the board must use its judgment to determine if the administrator was correct. The order of our meeting is as follows. First, cases will be called and a brief staff report and recommendation will be given. Following that, board members will ask any questions of staff they may have. Next, applicants or their representative will be given an opportunity to make comments to support the application or appeal. Next, all speakers for the item will be called. After we hear from speakers for and against the proposal, the board may permit the applicant a brief opportunity to clarify any points. The board may also ask questions of any of the speakers, but does not permit and will not condone any cross-examination or direct questioning by others. We have deemed the following time limits for applicants and speakers to be sufficient. 20 minutes for the applicants of appeals, 5 minutes for applicants of use permits and variances, 3 minutes for speakers representing organizations, and 2 minutes for those speaking as individuals. After the board has gathered all the information they need and has discussed the case, it will decide the matter by voting on a motion duly made and seconded. A majority is needed to approve any motion. Any appeal from the decision of this board must be made to the circuit court in accordance with state law. If interest is heard, you are welcome to stay for the balance of the session or leave at your convenience. Now I would like to briefly orient everyone to our virtual environment and to cover a few specifics about how this evening's meeting will run. Tonight's meeting is available to stream from the county website via a Microsoft Teams link. There is also a dial-in phone option for those who wish to use it. If board members, presenters, or speakers lose internet connectivity during today's meeting, please reconnect with us by phone. Please keep your phones and devices muted until you are called upon. Turn off sound to any other devices around you to minimize interference. For guests joining us via Teams, please turn off your video feed. Only board members will leave their cameras on. When called upon to speak, please turn on your camera and unmute yourself by clicking on the microphone icon that is located on your meeting command bar. The moderator does not have the ability to unmute you. The meeting chat is active for presenters or board members who need technical assistance only. The meeting chat should not be used for discussion, public comment, questions about agenda items, or requests for more information. All public comments must be shared verbally for the record during the assigned public testimony period. Board members, if you wish to be recognized to speak on an item, please seek recognition verbally as usual. If that is unworkable, you also have the option to use the raised hand function. In any case, once you have been recognized, you may unmute yourself. All voting today will be taken via roll call. To applicants and public speakers. Public speakers and applicants, you will be called upon by county staff at an assigned time. Pre-registration to speak at today's hearing was requested. We will accommodate any additional speakers only if time permits. Public comment will take place within the timeframe stated earlier, the same as we would at an in-person meeting. During public comment, a speaking timer will be displayed on the screen by staff. If you are dialing in by phone and unable to see the screen, we will provide an audible warning when 30 seconds are remaining. You will be muted when your time is concluded. Lastly, this is a public forum. Today's meeting will be recorded and posted on the county website. All information associated with today's meeting, whether written or spoken, is subject to the Freedom of Information Act requirements. This concludes the introductory remarks. Mr. Rizzi, would you please call the first item?
Madam Chair, before I call the first item, there has been a request made to modify the agenda of the meeting this evening. The fourth item on the agenda, that's case V-11582-20-UP-1, has asked if they may be able to be advanced in the agenda because they are joining from France and the hour is already quite late there.
Colleagues, any objection to us reordering the agenda to hear this item first? Mr. Rizzi, there's no objection. Would you call this item, please?
Yes, Madam Chair. Case number V-11582-20-UP-1 is a use permit request by Timothy M. Warren and Kristen K. Gower, the owners, to permit street setbacks of 16.2 feet to the areaway, 16.5 feet to the stormwater planter instead of 21 feet as required, 18.9 feet to the bay window instead of 23.5 feet as required, and 20.9 feet to the wall instead of 25 feet as required, all from the easement for street purposes adjacent to the 17th Street North right-of-way, regarding a new one-family dwelling in the R6 zoning district on the premise known as 1623 North Roosevelt Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you, Mr. Rizzi. Is there any supplemental material?
I have no supplemental material for this item, Madam Chair.
Sure. All right, any questions of staff?
Madam Chair,
Mr. Owen?
has the zoning administrator made a determination as to whether or not this parcel is a corner lot as defined by the ordinance?
There has been no determination by the zoning administrator, though this is a corner lot as defined by the zoning board.
You believe, okay. We haven't done book, bell, and candle, but you view it as a corner lot.
Yes.
And why do you say it's a corner lot?
Because it is a property at the intersection of two or more streets where the angle is less than 135 degrees.
And the fact that there's a county parcel to the west of it that's not currently being used as a street does not bear on that question?
So it's actually not a county parcel. That is just the simple right-of-way. That is the street as far as zoning is concerned.
Is the fee ownership with the applicant or with the county?
With the county.
Okay. Oh, I see. It looks like a lawn, but it is, the county believes it to be a street, even though it's not paved.
From a zoning perspective, that is the street.
Okay. As part of this project, the applicants appear to be proposing to build certain improvements in that right-of-way. What looks like a lawn, but is actually a street. The drawings depict a driveway that appears to extend off their property line and curve towards 17th Street. Have the applicants already secured permission for this driveway to be in this position? Does the BZA need to take any action on this?
My understanding is that the applicants have not yet received permission to build the new curb cut and associated driveway over the street right-of-way. And the BZA doesn't need to take permission because the approval of the curb cut and the driveway come from the Department of Environmental Services because that's technically the road and not the applicant's property.
The drawings appear to depict a front stoop less than 20 feet from the Roosevelt Street property line and a front porch and stormwater planter that are less than 25 feet from the Roosevelt Street property line. Do these setbacks require BZA approval?
No. Porches and stormwater planters are allowed a 4-foot encroachment towards street property lines, so they can be as close as 21 feet. And the stoop, it's staff's understanding that that's actually the landing at the base of the stairs and is at grade, and so is an allowed position.
So in sum, if we vote to grant this use permit, the applicants still have to go to the county and arrange to get permission to build their driveway.
Correct. DES would still have to approve the driveway location.
Okay. Thank you.
Any other questions for staff? So, Mr. Rizzi, Ms. Freshman, please.
Yeah, my concern was also about the driveway, not just the drawing, but when you look at the photo on the screen, it looks like it literally is on the corner. And I had some difficulty navigating into that street anyway. I'm glad to know that people who know more about these things than I will actually look at that before they permit it. Because to me, it looks dangerous to have a driveway coming out right at the intersection of two streets, and one of which bears quite a bit of traffic.
I don't know that that was a question, but my understanding is DES does have some pretty standard regulations when it comes to driveway placement, and that does include a prohibition on driveways being located too close to the intersection. So it may be that the location shown on the drawings tonight will not be allowed by DES, and if that's the case, the applicants would have to find a new location for the driveway that still allows for the structure to remain where the BZA approves it, if they choose to do so.
Thank you.
Just to follow up, Mr. Rizzi, so the location of the driveway that part that is on the applicant's property, is that being approved by the BZA?
It's not a request made to the BZA. Driveways, from a zoning perspective, are allowed to be anywhere on the driveway. They're just counted towards lot coverage. So the applicants have requested no permission from the BZA for that driveway, nor do they need to.
And the fact that it's on the drawing that we will refer to in the approval is not material.
I mean,
let's say they're not. Sorry, go ahead.
I would say it would depend on the conditions that you apply to any approval that you may grant. You can certainly say that, you know, the building shall be constructed, or the footprint of the building shall be constructed in accordance with the drawing shown, and that would take care of it because the driveway is not part of the building footprint. Okay. If you said that all of the structures need to be, you know, built in accordance with the drawings provided to the BZA, that could be problematic.
Okay. All right. We will note that. So, all right. So knowing that this, which is the front, the side and the rear setbacks are all conforming, right?
Yes, it's really just the street setback against 17th Street North, and it's primarily because the property has an easement for street purposes along that street. Okay. I think that they meet most, if not all, the setbacks if that easement were not there. So
5.5 to the window well is permitted.
Yes, window wells are allowed a 4-foot encroachment on an 8-foot side. They can be up to 5 feet from a side property line.
All right. And the chimney, are chimneys really counted at all?
Chimneys are allowed an 18-inch encroachment.
An 18-inch encroachment. So that also works. Okay. All right. Any other questions for staff? Let's hear from the applicants.
Good evening, fellow board members. I appreciate your service to Arlington County. We thank you for your time tonight. We apologize for any confusion that we may have had in thinking this was a we admit that a lot of the technicalities of setbacks are beyond us, and we do have a representative from our firm here tonight. But I think we went into this project in good faith in wanting to choose a model that is actually a sister model of the one next door, and hoping to have the same house in the same line as the neighbor. We do feel that this house would fit well in the neighborhood, and that we wanted to improve the quality of our lot for the sake of the whole neighborhood. We certainly enjoy living there, and we love Arlington, and we hope that you will favorably consider our request. Is there anything else you want to add? No. That's it from us. We're here for any questions.
All right. Thank you very much. Mr. Rizzi, do we have speakers?
No additional speakers have signed up for this item, Madam Chair.
Thank you. Board members, any questions for the applicant? Mr. Owen?
Yes, there does not appear to be feedback from the across the street neighbor at 1700 North Roosevelt Street. Can you let us know what outreach you made to that neighbor across the street from you?
Certainly, thank you. That's a very fair question. I knocked on every door of our entire neighborhood multiple times. If I'm not mistaken, that house, the residents are a Chinese family or group of friends. They do not speak English well. Our interaction with them has always been sort of positive in that we wave, but there's never been a real conversation. I did knock on their door multiple times. I also believe they are renters, so I don't know that they are the actual landlord, but I definitely try. We've never had an issue with them in the past one way or the other. I just don't believe they were there at the time that we were trying over the course of our last week in Arlington before moving to France on government orders. But I did definitely attempt to.
Thank you.
Any other questions for the applicant?
What are your,
I'm sorry.
Madam Chair,
No.
I do have another question.
Okay, go ahead. I was prepared to make a motion.
Oh, go ahead. You were going to make a motion. Yeah, I have a question.
Yeah. Okay,
Go ahead.
Mr. Owen.
So about this driveway, have you begun discussions with the county about securing permission to build the driveway in that location?
If I may, the representative of our building, the drawings tonight, Raj, he's on the call. If I may have him answer that question, I know there was back and forth with the county. I know they have also proposed an amendment to that drawing, but he is much more aware of the physical description. It's Raj who's on the line tonight.
Yeah.
Thank you. Raj, are you with us? Can
Yeah.
you turn on your camera?
Sorry, my camera doesn't work, but
Okay.
I do have, the microphone.
Okay, could you identify yourself, please?
Yeah, my name is Yubaraj Buratoki. I am the engineer for this property. I prepared this plat for the BZA application. As far as the driveway location goes, I saw two plots on the application. The one with the sign and shield is the current one. I did have the conversation with Amos, the reviewer at DES, and then he pointed me that it has to be at least 30 feet from the back of the sidewalk, along the Roosevelt Street. And the plot with sign and seal is 30 feet from the back of the sidewalk, existing sidewalk, Roosevelt Street. So I'm hoping this is what he was looking, unless there is any other issues. Those are the recent conversation.
So could I clarify, because there are two drawings in our packet.
Yeah.
You're saying the one that we should be considering is the one that has the seal on it.
Yeah, that's right. That's correct.
Okay. And that in your opinion, it conforms with what staff was requesting.
Yeah, that meets the the county requirement, which is 30 feet from the street, but it is actually 30 feet from the back of the sidewalk.
Okay. That's helpful. Thank you.
You're welcome.
I have another question on the
Mr.
same subject. Would you have any objection to us putting a condition in this use permit that requires you to make sure you've got that permission from the county before you start further construction work? In other words, my concern is that for whatever reason, you would hope that you'd get permission for that driveway and start construction on the house, and then realize or be told by the county that whoever talked to you the first time, they didn't know what they were talking about, and you cannot build the driveway on this side at all. And then if you already had started construction on the house, your remaining spot to build the driveway might need to be next to your neighbor on 17th Street. And then the neighbor might feel like they wanted to come talk to the BZA about that configuration, right? So to avoid that, I don't think, since you haven't finished your discussions with the county, we probably can't require you to build the driveway exactly as it's shown in the drawings. Might change a little bit, but I think I'd be interested in asking you to be sure to get permission for a driveway on that side before you proceed with the rest of the project. Do you have any concerns about a requirement like that?
To me?
Either
Yes.
applicants or the contractor.
Hey, Christine, would you like to?
Actually, I would, to be honest with you, I would prefer such a you looking out for us. I don't want to be in a situation where we're building a house and can't do a driveway either.
Yeah.
But so I appreciate you adding something like that, because I certainly don't want to proceed without 100% certainty. But I will defer to Raj on the mechanics of how this should all work. So go ahead, Raj.
It's hard to tell, but this is the corner lot, and then if we meet the minimum requirement, 30 feet from the street, as per the DES are joining our county own regulation or just the internal memo, then we should be able to build the driveway at this location, because the 17th Street side is not viable for the driveway because of the topography. It does not work on that side, and being in the corner lot, I thought we will have the permission to build the curb cut on that location.
We hope you succeed too. My question is, sometimes county staff will tell someone, oh yeah, it's fine. And then when they finally get there, they say, oh, no, they told you wrong. So I think we don't have enough information to be sure that you can proceed with this design, as proposed, for sure. And so I think if for whatever reason, though we hope and expect that it'll be fine, if for some reason that driveway turns out to be a problem, I think we'd like to see you again and re-examine the project, is what I'm saying. So that's my intention, and I don't think further discussion from me is necessary.
Ms. Freshman?
Yep.
I think if I understood the engineer correctly, the plat which is signed and dated 8/7/2020, he believes conforms with the county regulation about 30 feet from the corner. And whereas the one that's more colorful and caused us heartburn, we would ignore. And I frankly see in condition 1, if we added the language that referenced that particular plat, there could be any number of cases that we would deal with where we reference materials in a report that could run into a chainsaw later on. So I'm comfortable with the fact that the engineer has said to us that is the one that, while they may prefer the other one, this one with the signature and the date on it is the one that he believes conforms with what he's been told by the county. And I would be comfortable referencing that as part of the condition.
That's fine with me.
Which would mean that if for some reason staff comes back and says this driveway is not where they wanted, this item would have to come back to us.
But if that doesn't happen, it can go forward. And it seems to me that they've submitted one drawing based on information they've been told, which we hope is accurate.
Yes. Okay. Just so the applicant is clear that we're going to approve we're going to consider the plat with the seal as representing what you have permission to build. But if that changes, then you may have to come back.
Yep.
Okay.
I agree.
That makes sense to us too. Thank you very much. Mhm.
Okay. Ms. Freshman, were you going to make a motion?
I was. Thank you very much. I move the Board of Zoning Appeals approve the attached proposed resolution for use permit V-11582-20-UP1, subject to the conditions listed, with the addition to condition 1, after the statement that says footprint shown on the survey, you would add signed and dated 8/7/20. And also then adding the third condition that we would like to see this built within 3 years or it becomes void.
And is there a second?
I'll second it.
Are you banished from the country in time to come back and build it in 3 years? Applicants?
Yes, it is a 3-year tour here, but we are still legal Arlington residents and plan to proceed with the building right away if approved.
Well, I think if the rest of the BZA members consider that to be a constraint because of the unusual circumstances, we don't have to add it.
3 years should do it.
Okay.
Madam Chair, I have a question about the altered condition language.
Mr. Owen?
So the condition language does not specifically mention the word driveway. And I'm wondering if Mr. Rissy thinks staff would interpret that to include the driveway location.
Madam Chair.
One moment. We have a question to Mr. Rissy.
Honestly, I would say no.
All
I
right.
would say
In that
that's
case,
specific to the structures that the applicants are requesting approval of the BZA for.
in that case, I would ask unanimous consent after the language added by Ms. Freshman to add the words including the driveway footprint.
Any objection?
Madam Chair. Could Ms. Freshman read the proposed condition back again in reference to the plat?
Certainly. Ms. Freshman?
Okay. What I said was in condition 1, after these words that say in accordance with the footprint shown on the survey, I would add that was signed and dated 8/7/20, which is the way 2020. To
Okay.
distinct, is that sufficient, or did you want to change it?
No, I'm okay with that in addition to Peter Owen's unanimous consent.
Okay.
All right, we have a motion made by Ms. Freshman, seconded by Ms. Clark. Is there any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to grant the use permit has been approved. Carries. So you have your motion with the slight question of the driveway location.
Thank you very much. We really appreciate it.
Right.
Have
How
a
do you
good sleep.
have to go say something
way.
French, right?
Merci beaucoup. Merci.
Thank
Au
you.
revoir.
Revoir. Thank you.
Good night.
Thank you.
Mr. Rissy, would you call the next item, please?
The Next item is case number V-11563-20-VA-1. Is a variance request by Zach Pride, the owner, to permit a right side setback of 8.3 feet from the side property line instead of 10 feet as required, and to permit an addition that is greater than 50% of the floor area contained in the existing building as of July 15th, 1950, regarding new two-story rear addition on two-family semi-detached dwelling in the R818 zoning district on the premise known as 327 South Wayne Street. Staff recommends that the board adopt the attached proposed resolution granting the variance with conditions.
Thank you, Mr. Rissy. Any questions for staff? Okay. Mr. Pride, were you able to join us?
Yes, we were. Okay.
So,
The iPad didn't work, so we had to go to the computer.
Oh, we see you.
Yeah.
Good evening.
Good evening. How are you?
We're doing fine. Anything you'd like to add tonight? I know this is a carryover, so we've heard from you.
Oh, sure. Well, first of all, me and my wife, we wanted to say thank you for just taking the time out to do this. I know that everybody's busy, and we really appreciate your consideration for this variance. So we were doing a little bit of research since the last time we spoke, and I went ahead and got some, upon the recommendations of Mr. Owen and by some suggestions of Mr. Rizzi, I went and canvassed some places in like the street next to us and the other street, 2 streets down from us, which are in the same district, I'm sorry, the same zone. And I put those pictures in. I don't know if you have those in front of you or not, but I can describe them if you don't. They're essentially the same style home, the same year, and it just shows that, and I had no idea. Actually, we both had no idea. Our place is really small in comparison to a lot of these places around here. So it is actually it's not common to have a home this small in the area. And I went to other districts, other zones within the county, but I just walked around my neighborhood to get particular ones that you see. I also took pictures of the home just to kind of give you an idea of what we're working with. We can only put our full-size bed inside the master bedroom without it being in front of the window. You know, you get cold at night during the winter time. So we found that if we wanted to have 2 nightstands, we had to get a full-size bed. There was no other way to do that, and we both like our nightstands. So the other room, the guest room, which is the office, which is where we are adequately sized for an office, not adequately sized for a guest room or a second bedroom, in my opinion, because it only fits a twin-size bed comfortably with the same kind of thing. And then I showed the back. Oh yeah, and then if you see the laundry center, there is no. I mean, these laundry centers aren't really that great. I wish that we could use the ones that kind of stand up, that we could put more clothes in. Once again, for the bigger family, it doesn't really quite work out that well. And you can only fit that size in that particular place, which is a standard size closet, not a walk-in. So then I also took a picture of the dining room, which once again, we don't have space because we're musicians and I have a really big instrument. And that's actually, I have 2 of those. The second one's not in the place because I can't fit it anywhere. So me and my friend just joked about that because he has the same kind of issue, except he lives in Maryland. That's a different story though. Anyway, we don't have a place to eat and we would like a place to eat. So the last pictures are the pictures of the yard. It's a huge yard. We don't really use, well, she gardens a lot, so we will have enough, and I thought that through. I didn't want anything too big that would impede gardening for our family. And there's plenty of room for gardening because we're not even using the room as it is right now. It's right where the pergola is, and it doesn't even go all the way into the edge of the pergola. So, and a quick story since I have 1 minute and 31 seconds left. My neighbor, which is 2 houses down from me, she has the house, except she has a little bit bigger roof in the sense that it was oh, you can see it 2 2 houses down. Yeah, that one, the one with the white roof, or I guess the gray roof. She raised 3 in that home, and she said that she had to fit them in there with a broom because it was so little space. Now, granted, she has a bigger attic, so she could make a finished room to fit 2 people in there. But she said that when someone had to go, that was a serious. When 2 people had to go, it was a serious issue because then the backyard had to be used. And I really don't want to run into an issue where the backyard has to be used with more people. So I thought it was, I wanted her to talk, but I think she was embarrassed by that story. But I said I'm definitely gonna tell that story. She was asking if we hadn't disapproved yet, and I said no, we have another month to look at this. Anyway, that's what I have to say, and thank you for your time. I know my wife, I don't know if she wanted to say something, but are you sure? Okay. All right. That's it.
Thank you, Mr. Pride. Any questions for the applicant?
Oh,
Eric?
yeah. Mr. Pride, can you give us a sense of how many properties you looked at for comparison, and whether you found any that were smaller? Did you only look in your neighborhood, or like what's the denominator there?
Right. So as I was saying, I looked in different zones with the same signifier, I guess the RA8-18. I looked in those, and what I noticed was that the ones farther away from us, in the other zones, yes, they were just much bigger. I didn't see any house that was our size except on our immediate street. But as soon as you go to the other streets, they're much more spacious. And I put that in the, I think one of the descriptions under the photos, the very first one, which shows the ones on Courthouse between the 2nd and the 200 and 400 block. They have basements and 3rd floor. And, I could tell that some were, I don't know if they were finished. I couldn't go inside people's homes. I felt a little weird already taking pictures of people's houses. But as per Mr. Rizzi's recommendation, I took pictures of the windows by the basement to show that they did have basements. But then I went on Zillow, and it also said that they had significant amounts of square footage, and I think I counted the homes, and I think I forgot what I said, but it was like 20 or something homes, I believe. Where was that? Or can't see it. Oh, I did. Oh, okay. I don't think it went on the PDF, but there was like close to 30 homes, 30 buildings, each of them being the duplexes, and they were all on Courthouse. And then the same thing was on Bike, which is the street right next to us. Unfortunately, I couldn't go east on the neighborhood because that's when we are on the street where the RA8-18 zone ends. But everything from the east, the east, all of those homes, they were much more bigger than ours. And
so you looked at, just to make sure that I understand, you looked at about 30 other homes that were all in the RA8-18 category. And as far as you could tell, yours was the very smallest. Is that right?
Yes, inside this particular neighborhood and other neighborhoods that I canvassed, definitely. No question about it.
Thank you.
Mr. Rizzi, we have no speakers, correct?
We have no additional speakers who have signed up, though.
Is there anyone here that wishes to speak on this one?
I have my contractor here for technical questions, if you have any.
Okay.
Mr. Hamid Mohammadi.
Okay.
Well, I guess I don't have anything to say. Sorry, guys. Hello. So, yeah, I mean, just go ahead. I mean, Zach said whatever.
Yeah, Mr. Hamid, we'll ask you if we have any technical questions.
Sure.
But no neighbors or anything else.
No.
Okay, great. Any other questions, colleagues? I will say, Mr. Pride, that your additional research was very helpful.
Oh, no problem. It was by the advice of Mr. Rizzi, so thank him for.
Do we have any further discussion? Is there Ms. Freshman,
Have a motion?
please.
I move the Board of Zoning Appeals adopt the attached proposed resolution approving the variance V-11563-20-VA-1, subject to the conditions listed and with the addition of the 3-year time limit.
Is there a second? I will second.
Madam Chair,
Mr. Miller?
I'd just like to speak to the motion before we take the vote.
Me too. You first.
Okay. I think this was a really difficult case. I mean, obviously the actual improvement is a very sympathetic one, and the county's rule limiting additions to no more than 50% of the main structure might be a bad rule in general. And if it is a bad rule in general, then the BZA should not be granting this variance. We should make the county board do its own work. If, however, this rule is only bad in rare cases, such as this one, then it's appropriate for us to grant a variance. So we sort of have to ask the question, when the county board passed this 50% rule, would they have been surprised that it would apply in this way on this property? Or would they have said, no, that's what we meant. We wanted, for example, maybe they would have meant, we want to have a few really tiny houses preserved in Arlington as really tiny, so that people who want really, really tiny houses still can get them. You know, it doesn't make a lot of sense necessarily when you put it like that, but it's possible, you know, and in fact, right now the county's doing a missing middle study that suggests that maybe there actually is a need for just this sort of thing. So I was really nervous that we were being asked to approve a variance that attacks the 50% rule overall and not the 50% rule on this particular property that the county board couldn't have really imagined. So I think that the applicant's additional research just barely pushes it over the edge for me in saying, okay, maybe this really is the very smallest RA 18 two-family home in all of Arlington. And if it's the very smallest, then a variance might be okay. But I think even though I'm going to vote yes on this motion, I feel like this is like every dog gets one bite, you know? So if we get more cases in the future where it's similar justification, we don't like the 50% rule, and by the way, our two-family home is really small, as many of them are. Most of them are small. The question that Mr. Pride was answering today was, yes, they're all small, but ours is the smallest. But I'm really not comfortable with the BZA being the place where more and more and more of the two-family homes exceed the 50% requirement, when really it's the county board that should do it. So I'll vote yes, but with serious misgivings.
Any other comments?
I
I
have a comment too, Madam Chair.
go ahead, Mr. Malik.
Okay, so I have the same concerns as Mr. Owen, and I'm not convinced that this isn't so general that the county board really shouldn't take it up. And I know there is a movement currently, and toward affordable places, smaller places, and plus, so I don't see an unreasonable restriction here, just because the place happened to start out small, because there are additions permitted. It's just there's that 50% rule, and also the hardship claim that it was small to begin with. That's actually addressed in the ordinance itself, because it talks about area. And here we're talking about a small area, so it fits into the 50% rule. And And I'm just not convinced, like I was saying, that this isn't so general that, there's not going to be, possibly a deluge. Because looking on these drawings, it does look like there's quite a few small places. If they all want to go against the 50% rule, then, as Peter said, we're going to have to explain, well, there was the one bite rule. And they're going to say, well, how is that fair? Giving the one bite in this case, that seems pretty arbitrary. So I think we need to think seriously about the precedent that this will set. And I think there's a lot to be said for putting this on the county board shoulders, because I think this is very ripe for change if the county board do that. But they've had quite a few chances, at least one, I would say, to change this, and they haven't. So I would vote against this.
Thank you, Mr. Melnick. Any other comments from board members? So I too struggled with this, and the issue is, I guess, you tend to expect a degree of uniformity in a district. That buildings in a district share some things in common, and one of them possibly being size, and the fact that the buildings in this district are not uniform in size is what this, to me, this case hinges on. I can't imagine that the board really was thinking about individual buildings as opposed to an area when it set forth the 50% rule. And therefore, I think the claim that this building is smaller has weight. Because while Mr. Melnick refers to area, it's the floor area. The board has put in the building floor area as a consideration. So I'm inclined to support this, but I could see myself easily not supporting other cases where I was not persuaded that the property was not similar to others in the district. Is there any other further discussion? All right, we have a motion made by Ms. Freshman, seconded by the chair. I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
No.
Ms. Clark?
Aye.
The chair votes aye. The motion passes 4-1. Mr. Pride, do you have a go-ahead to start your addition?
Thank you so much. It's really, really small. Trust me. I've been around the neighborhood. This is special. Thank you so much.
Thank you. We really appreciate it.
All right. Good luck.
Good luck and thank you. Good night.
You too.
Mr.
Good night,
Ricci,
everyone.
will you call the next item?
The next item is case number V-11566-20-UP-1. It is a use permit request by Carlton Davis and Sheila Leonard, the owners, to permit a right side setback of 4 feet to the porch, no eave, instead of 10 feet as required from the side lot line, and to permit an aggregate side setback of 12 feet instead of 18 feet as required regarding a front porch expansion in the R6 zoning district on the premise known as 5707 5th Street North. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. I'd like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed. There are some drawings that show different skirting options for the porch, as well as a letter of support from a neighbor.
Thank you. And this is a carryover. We heard this item previously.
Correct.
Thank you. Any questions for Mr. Rizzi? All right. Can we hear from the applicant? Mr. Davis or Miss Leonard, are you with us?
Hi.
Hi, we're here.
Hi. Good evening.
So as Mr. Rizzi just explained, I spent a lot of time talking with our neighbor, Tim Cripps, who called in on last month's call. And we discussed a little bit, I guess it's a really leafy area. And so he was hoping that we would have a side that was enclosed rather than open to basically for aesthetics so that leaves don't get stuck. So we talked about it a little bit and we went through some different options. And he basically said, as long as it's not open or lattice, that worked. And as Mr. Rizzi said, signed and approved. So hopefully that follows up on the question from the previous month about Tim Cripps and his wife, Jessica, whose last name escapes me. So that's where we are.
So could you describe your drawings and how that conforms to what was requested, the concern?
Sure. So Mr. Cripps was not sure as to exactly like kind of the aesthetic look of it because we had different colors and slightly different wood paneling on the previous drawings. So we had our architect draw 4 or 5 different options with kind of like the right dimensions and the right window. Some of the window placements had been from the original design. And so we moved, Tim pointed out those weren't there. And so we just got them all completely architecturally correct. And then we talked through, I mean, aesthetics I know isn't necessarily part of this board's jurisdiction, but you know, we talked to Tim and we were very, I mean, it doesn't really matter to us and it did matter to him. And so we kind of agreed on that. That's actually what we wanted anyway, for it to be enclosed. So now you have the enclosed drawings, or I think you should. And that's what the change is.
Enclosed in what way? Are you saying
Oh,
they're
I'm sorry.
enclosed in what way?
In the bottom, so that the bottom below the porch, he didn't want to have his leaves stuck in our lattice.
The porch is definitely a porch. It's not a screened porch. It's not a glass. It's an open porch.
Yes.
We're talking about under the porch between the ground and you know, where you sit, where you put your feet.
Okay. And this supplemental material that we got, there's just one option in here. Is that correct? You
I think there are 2. One of them is shiplap and one of them is wooden panels.
Is there one that you want us to include in the?
Yeah, the wooden panels. The wooden panels. I'm sorry?
Which one is the wooden panel versus the shiplap?
So the wooden panels is going to be number 1 and number 3.
And he's okay with either.
Okay.
And he's actually okay with, I mean, it doesn't matter, but he just wanted to kind of talk about like care on that side and stuff. So,
okay.
And make sure that the drawings were before we had a window there that shouldn't be, and it wasn't quite the right height and stuff, and just make sure it was all right, which now it is.
Yeah, we didn't know. I guess he said that in the prior, so we purchased the house from the grandson of the original owner from back in 1940, which is pretty remarkable. And over the past, many years, well, certainly over the past year since he moved back from Singapore, I guess he had been doing a lot of the maintenance on that side of the house, even though it's on our property now. He had been sort of maintaining it in the fall. And so he was concerned, rightfully so, I think, with continuing to do that now that we're there, and we'll pay closer attention to it. And we just wanted, I think he just wanted to make sure that was all shored up. My wife spent a lot of time talking about that.
Okay. Ms. Freshman?
Yeah, we have 2 plats, and I just want to confirm that the first plat seems to conform to the photograph, but the second plat extends the porch throughout, and which I thought was also the intent. So I just want to confirm that.
Okay, so the first plat on page 4, 6, I think on page 9, the first plat is the way that it is now, where the porch goes 3/4 of the way.
Right.
And then the second plat is what we're asking for, where the porch extends to the end of the current structure.
So we're both, so the porch will run the entire length of the front of the house and will be completely enclosed underneath.
Underneath.
Just underneath.
Underneath.
Yeah.
Correct.
Yes.
Yes,
Well,
ma'am.
there is a condition that it can't be enclosed. So
Correct.
Right, yeah.
Correct. I saw that on the proposal.
Yeah.
It won't be.
Yes, that's correct.
That's sort of standard for us.
Yes.
Yeah.
Okay, thank you.
So is there a way to distinguish this second plat as being the plat that we're approving?
I tried that, but there weren't page numbers or anything.
And they're both got the same dates on them. So we'll have to just describe it. The porch that runs the entire length.
Right.
Okay. Any other questions for the applicant? Well, thank you for that additional research and outreach.
Yes, of course.
Madam,
Mr. Owen?
I'm ready to propose a motion for discussion.
All right.
I move that the Board of Zoning Appeals approve the attached proposed resolution approving the use permit V-11566-20-UP-1, subject to the conditions listed, except with an additional condition with a 3-year expiration, and modify condition number 1 after the date to include the words as modified by and superseded by the supplemental drawings submitted on October 14th, 2020, including full enclosure of the area below the floor of the porch with wooden panels. And then pick up the sentence from there.
All right. All right. Is there a second?
Second.
Seconded by Ms. Freshman. Is there any discussion?
Did you think it was necessary to distinguish the plats to the one which was the full width of the house? Peter?
Mr. Owen?
No, I think that's implied by the nature of the application.
Okay.
The grant of the use permit doesn't really make sense unless they're doing that. I will say, though, that drawing confused me a great deal for the first day I looked at the packet, but I've now decided, after studying this for 2 months, that there's only one way it can go.
Thank you. I'm sorry.
Any additional discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to grant the use permit carries 5-0. You're all set.
Thank you so much. I really appreciate your time.
Thank you, and merci beaucoup. Thank you.
Thank you so much.
Night tonight. Okay.
Yeah, thank you.
Thank you.
Mr. Rissy, would you call the next item? Mr. Rissy, are you muted? Start again.
The next item on the agenda is case number V-11571-20-UP-3. But I will note that this is an item that the BZA deferred to the November 18th BZA hearing. It is on this agenda because we placed it on the agenda before the last hearing, wherein you deferred it to November. So no action is needed for this item.
So before we proceed, is there anyone here wishing to speak on this item? Okay, I think we can just move on.
The next item on the agenda that we haven't already heard is case number V-11583-20-UP-1. It is a use permit request by Catherine and Gary Harvey. The owners submit a street setback of 18.6 feet to the porch, 17.6 feet to the porch eve from North Larimore Street instead of 21 feet to the porch, 19.5 feet to the porch eaves as required, regarding a one-story front porch addition in the R6 zoning district on the premise known as 1017 North Larimore Street. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions, and I'd like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed. It's a supplemental document from the applicant detailing their outreach efforts to their neighbors.
Thank you, Mr. Rissy. Any questions for staff? All right. Is Catherine or Gary Harvey with us tonight?
I am here. Can you hear me? I feel like my mic.
All right. I hear you. I don't see you. Do you have your camera?
Let me see. I'm trying to turn the camera on, but it is not allowing me, and I apologize. All of our devices are being used by middle school students in the house, so I'm using my work computer, which may have a weird block on my Teams just because of the nature of my job for my camera. I'm sorry.
That's fine. Sometimes it takes a while to connect, but if it doesn't, just being able to talk to you is fine.
Okay, thank you. Thank you for your time tonight. This is my first outreach with the BZA. My husband and I both grew up in Arlington. We're natives, have lived here our whole lives other than our college years, and love our neighborhood, love our county, and would very much like to add to the appearance of our home, in addition to making it a more inviting space for our neighbors to commune with one another. Our adjacent neighbor has a front porch, and we've enjoyed many evenings out there together in community. So I appreciate your consideration for our request.
All right. Thank you. Any questions for the applicant? All right. Discussions with the board. Any discussion on this item? Ms. Freshman?
Motion?
Go ahead.
I move the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11583-20-UP-1, subject to the conditions listed with a 3-year time limit.
I'll second it.
Seconded by Ms. Clark. Any further discussion?
Madam Chair,
Mr. Owen?
I'll just say that the additional supplemental material submitted by the applicant about outreach to the across the street neighbor was helpful.
Yeah, it's always appreciated.
Thank you.
If there's no further discussion, I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion granting the use permit carries 5-0. The use permit is granted. You're all set.
Thank you all very much. I really appreciate your time.
So what neighborhood did you grow up in?
I grew up in Ashton Heights. Actually, the house I grew up in isn't there anymore. I was on the corner of North 9th Road and Irving Street. So a couple blocks off of Clarendon Metro, and it's now condos and townhouses. But I went to Drew Elementary and then HB Woodlawn.
Yay.
Okay. All right. Well, it's good that some people are native here.
Thank you.
Thank you very much.
Take care.
Mr. Rissy?
Yes, the next case is case number V-11584-20-UP-1. It is a use permit request by Ann P. Lane and Scott H. Lane. The owners permit a rear setback of 10 feet to the accessory structure outdoor fireplace in the rear lot line instead of 25 feet to the wall as required, regarding a new accessory structure outdoor fireplace in the R6 zoning district on the premise known as 1036 26 Road South. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. And I'd like you to please note that there's supplemental material for this case that came in after the application packet was assembled and printed. And we have a number of speakers who have signed up to speak on this item.
Thank you, Mr. Rissy. Any questions for staff? And Ms. Freshman?
I don't have a question, just a comment that after last week, I appreciate that this is before the fact.
Yes.
Mhm.
Mr. Owen?
Thank you, Madam Chair. Does Arlington County have any master plans or land use and zoning related policies related to the production of smoke from outdoor fireplaces or similar devices?
Not that I'm aware of.
Thank you.
All right, any other questions for staff? All right, is Ann Lane or Scott Lane with us tonight?
Here. Ms. Malice, they're available for questions, as am I. Lauren Riley with Walsh Colucci is going to do the presentation.
All right, and you are Ms. Puskar?
Sorry, this is Kathy Puskar. Yes, I apologize, with Walsh Colucci.
All right, so who's making the presentation on behalf of the applicant?
Hi, Madam Chair, I will be. Are we ready to start?
Yes.
Good evening, Madam Chair and members of the board. I'm Lauren Riley with Walsh Colucci. We represent the lanes with regard to this BZA use permit application. I'm joined tonight by Kathy Puskar of my firm, the lanes, and their landscape architect, Karen Barnes, with Northview Landscape Design. They will be available for any questions that you may have. The lanes are requesting approval of a use permit to locate an outdoor fireplace 10 feet from the rear property line. The lanes are in the process of renovating their backyard to create a more comfortable outdoor gathering space. Due to the coronavirus pandemic and social distancing recommendations, outdoor space is at a premium, and this proposed fireplace is key to achieving their desired gathering space because it will extend the fall and spring seasons during which the lanes, their family, and their friends may spend time outside together. Regarding placement of the proposed fireplace, the existing patio wall prevents the outdoor fireplace from being located within the required 25-foot setback for accessory structures. When considering where to place the fireplace, the lanes and their landscape consultant, Ms. Barnes, evaluated the best location that would maximize the seating area to permit social distancing, shield the fireplace from view by the rear neighbors, and not require the removal of trees or other plantings. The lanes strategically chose the location of the fireplace to shield it from view by the rear neighbors as it is behind their shed, to allow for socially distant seating, and to retain the existing trees and plantings in their backyard. The location of the fireplace is 24 feet from the Lanes house, approximately 53 feet from the Hopkins house, and approximately 40 feet from the nearest corner of the Parallax house. Regarding design of the fireplace, the Lanes, with consultation from Ms. Barnes, decided on the current design not only because it is aesthetically pleasing, but also because the chimney allows the smoke to dissipate at a greater height than a fire pit or a fireplace with a lower chimney would. Staff has appropriately found that the application satisfies all of the required criteria for approval of a BZA use permit. We are aware of the information submitted by the Hopkins, as well as the email submitted by the Parallax today expressing their opposition to the use permit and their concerns about the smoke and the impact of smoke from the proposed fireplace. Please note that the Parallax live elsewhere and their home at 2625 Fort Scott Drive has been vacant for a number of years. We respectfully disagree with the rear neighbors and do not believe there is a valid basis to deny the application. As stated previously, my clients took their neighbors into consideration with both the design and the location of the fireplace. Similar to smoke from wood-burning fireplaces within homes, outdoor fire pits, and charcoal grills that are found throughout Arlington County, the proposed wood-burning fireplace would not adversely affect the health or safety of the neighbors. Ms. Barnes has designed numerous fireplaces throughout the region with similarly constrained sites. It has not had one instance of a fire generated by embers coming from a chimney. As such, the proposal will not be detrimental to the property or improvements in the neighborhood. Furthermore, the proposal will promote compatibility of development within the surrounding neighborhood and is not in conflict with the purposes of the master plans and land use and zoning related policies in the county. We've also submitted letters from 11 different neighbors who have all reviewed the lanes proposal and support the proposed fireplace and this BZA use permit application. The the Lanes are eager to move forward with this final piece of their backyard renovations. For the reasons previously stated, we respectfully request that you approve this BZA use permit application. Thank you.
Thank you, Ms. Riley. That completes your presentation?
Yes, Madam Chair, it does. Thank you.
Colleagues, we can stop here and ask questions of the applicant, or we can hear from the speakers. Since we have a number of them, shall we just proceed? All right, Mr. Rizzi, let's call the first speaker.
First speaker on our list is Charles Hopkins. If you're with us, please turn on your microphone and/or video camera.
Okay, I think we're live here. Actually, I'd like my wife to speak first, if that's okay.
Please, Ms. Hopkins, proceed.
Okay. Thank you for your time tonight. We are Martha and Charles Hopkins, owner of the property located at 2633 Fort Scott Drive, and our backyard butts up against the Lane's backyard. We are asking for the BZA to deny the application for the following 5 reasons. The proposed fireplace is in violation of the setback codes, 25-foot offset. It affects the health and safety of persons in the neighborhood, us, our health. It is detrimental to the public welfare and injures property, our property. There is no similar structure approved by BZA. 5, there are reasonable alternatives that would mitigate or even eliminate our concerns and also comply with the setback requirement. I'll be addressing the first 2 items and my husband will address the remaining 3. Shifting the responsibility. The applicants want a permit to build the fireplace closer to our property and away from their property so they can shift the smoke from them to us. Zoning ordinances govern the placement of structures on properties, especially setback requirements, to prevent this exact scenario. When one neighbor's structure interferes with another neighbor's use and enjoyment of their property. 2, health and safety. The fireplace with its chimney would pipe smoke into our yard for hours when it is in use. Our 2 lots, even though we're back to back, are on a steep gradient, with our house sitting on a hill higher than their property. When we stand in our backyard, we are about level with the applicant's 2nd floor. The fireplace's 12-foot 3-inch chimney sits just over the top of the fence, and it would empty the smoke and gases right into our yard. We are 67 and 68 years old and have a medical history of vascular issues. Smoke is a serious danger to our health and safety. We have our children and grandchildren over regularly in our backyard, and those visits would be impossible if the applicants are using their fireplace.
Madam Chair.
Mr. Owen?
I just note that there's 2 individuals speaking, but the time was allotted for just 1 person. So perhaps we should allot 2 minutes for the next speaker.
Do you have additional comments?
I do, and actually we submitted 2 requests, one in Martha's name and one in my name to speak.
Okay, you may proceed.
All right, continuing, number 3, the 12-foot chimney will only be 14 feet away from the cedar shed. Any embers or sparks from the chimney could easily fall onto the shed and start a fire. Number 4, there are no similar structures surrounding the lot in question approved by the BZA. This is a fireplace, not a garage. There are unique characteristics for a fireplace, especially when considering setback requirements. We understand that a usable outdoor living area is important for homeowners. However, the applicants failed to present evidence in their application of how their proposed use would affect other homeowners. Number 5, reasonable alternatives. When the applicants first informed us that the fireplace was wood burning, we were immediately concerned with how it would affect our health and the use of the yard. We asked if they would consider a cleaner burning natural gas fueled fireplace in lieu of the wood fireplace, and even offered to split the cost. They didn't accept this alternative and failed to consider any number of other alternatives, such as changing the proposed location of the wood burning fireplace to conform with the 25-foot setback, or using another means of heating their patio, such as a restaurant type patio heater or a natural gas fueled fireplace. Unlike burning wood, combusting natural gas only produces water and vapor and carbon monoxide. And burning wood creates more, which are the exact products we exhale, by the way, carbon dioxide and water vapor. Burning wood creates a more toxic byproducts such as carbon monoxide, formaldehyde, and other toxic pollutants. Natural gas is easy on, easy off, and virtually zero maintenance. In conclusion, we're simply asking for the same protections of the zoning ordinances as everyone else. The setback ordinance is not just a bureaucratic inconvenience. It exists as protection for the applicant's neighbors, and we deserve that protection. The applicants seek to build an impermissible fireplace, and placing that fireplace very close to our property will generate a health risk in the form of smoke and a safety risk in the form of fire. There are no justifications for constructing this fireplace, and both neighbors who will be most affected vehemently oppose its construction. Moreover, the applicants have thus far refused to consider other alternatives that either A, do not violate the setback requirements, or B, mitigate the risk to health and safety of their neighbors. For all these reasons, both neighbors asked the board to deny this application. And we thank you very much for your time. It's truly appreciated.
Thank you, Mr. Hopkins. Thank you, Ms. Hopkins. Mr. Rissy, would you call the next speaker?
The next speaker on our list is Samia Siddiqui. If you're here, please turn on your microphone and/or camera.
Yes, this is Saima Siddiqui. And again, I have, I think, some issues with this is my work computer, so I cannot turn on the camera.
That's fine.
Yes, so I live across from Ann and Scott Lane. We've been in this house for about 6 years now. And what I am here to say is that I am in complete agreement with them for proceeding with this fireplace. While I do understand some of the health and safety concerns as raised by the neighbors on the backside, I also recognize that, you know, whether you are building a wood burning fireplace or a gas fireplace, issues will pretty much be exact. Health and safety is an area that I am very involved in. I am a healthcare professional, and I am in this field. While I do understand that oftentimes there are triggers for people to be getting health concerns, but living in this environment in this day and age, you know, those concerns are everywhere. I don't think that Ann and Scott, the kind of reasonable people they are, that they would be burning wood pretty much on a regular basis all the time, but rather, you know, in a manner where it will be conducive for the neighbors to be able to go and enjoy it. And they're aiming to build something which is going to bring more people around the fireplace, and not let people be away from the fireplace. So I do consider that they should proceed forward with building the fireplace.
Ms. Siddiqui, does that conclude your comments?
Yes, it does.
What is your address, please?
My address is 1037 26th Road South.
Thank you. Mr. Rizzi, would you call the next speaker? Molly Watson.
The next speaker on our list is Molly Watson. If you are here, please turn on your microphone and/or video camera.
Hi, can you hear me?
We can hear you.
Hello?
You want us to see you or hear you?
I'm here. I see me. I don't know if you can see me.
All right. Well, there you go. We see you now.
Okay. So I am a neighbor of Ann and Scott's. I've been a neighbor of theirs for 20 years. Actually, they lived here a year or two before we moved in. And I just wanted to attest that they have been incredibly conscientious and friendly neighbors. We both went through a huge remodel about 12 years ago, and they set the standard by letting, you know, we did it about the same time, by just reaching out to neighbors and being incredibly conscientious and making sure it didn't impact each other. I, will say they did the same on this. I was a little shocked that they had to go through this process for an outdoor fireplace. I was thrilled, thinking that it would be great to have an outdoor fireplace under the conditions of COVID where we need to stay outside. And other than just expressing my support as a neighbor, I also wanted to address something I just heard from the neighbors behind them, which is they had said that they had deliberately put this fireplace in a position to be further from their house and closer to the neighbor. And I know their lot and I know our lot. I mean, we are neighbors on the same side of the street, and they couldn't have done that. Our lots are a little small. We are essentially in a city, and I thought they were incredibly conscientious in where this fireplace is. I also know that I have a husband who wants to grill a lot, and that occasionally it does create smoke, and occasionally I smell the smoke of other people's fires and other people's grills, and it doesn't exactly inhibit our use of our yard. It is a neighborhood. This is what we do, and we just accept that among each other. So unless you have any questions for me, I just wanted to express our support as a family for the Lanes and their project.
Thank you, Ms. Watson. What is your address, please?
It's 1022 26th Road South, Arlington, Virginia.
1020. So you're one house over from
Yes.
the applicant. Okay.
On the same side of the street.
Got
Yeah,
it.
we're sort of a little peninsula.
All right. Thank you very much.
You're welcome.
Mr. Rissy?
The next speaker on our list is Josh Turner. Josh, if you're with us, please turn on your microphone and or camera.
Good evening. Hope you all can see and hear me.
I'm looking for you. We definitely hear you. Yes, we see you and hear you.
Okay, great. Hi, my name is Josh Turner. I am across the street from the property in question at 1043 26th Road South. We've lived here for about 12 years now, and I want to echo basically everything that Molly Watson said about the Lanes as neighbors, their conscientiousness and their willingness to work with us and sort of take us into account in thinking about where they're going to site this fireplace. I too was a little shocked that the bureaucratic process was as involved as it is to build this structure. I fully support it. I think it's entirely reasonable to have a structure like this in a neighborhood like ours, especially in COVID times, but even not in COVID times. I think having wood burning smoke, the occasional grill, wood burning fireplace, wood burning fire pit is absolutely something you would expect in a neighborhood like ours. I would expect all of our neighbors to indulge in that kind of activity. And I don't think there's anything at all unreasonable about what the Lanes are proposing to do here. And I also wanted to echo something that Molly said about the position of the fireplace. I heard, I think it was Lauren Riley, present the distances. And in fact, the distance from the fireplace to the Lanes house sounded like it was 24 feet, as opposed to 53 feet from the Hopkins house. So in fact, it's not closer to the neighboring house than it is to their house. Anyway, that's all I wanted to say. Fully support this application. I think it's going to be a really nice addition to the property, and I think it's actually going to improve property values, not drive them down.
Thank you, Mr. Turner. I think the last speaker we have on our list, did you call them, Mr. Rissy?
Yes, that's Charles Penry. Charles, if you're here, please turn on your microphone and or camera.
Hi, I'm Charles Penry, live at 1030 26th Road South, so I'm immediately east of the Lanes. We probably have the most adjoining or most adjacent property next to theirs. We have two kids who are 7 and 10 years old, and we've lived there for 9 years and find the Lanes to be very fine neighbors, and we support their permit proposal. I would point out that I did some research, and I think I've done research over the years. The prevailing winds are usually from the west, and the reason I know that is I live next to the Watsons, and you heard from Molly earlier. Every time I light up my big green egg, and it's charcoal burning, the smoke goes into their yard. I know that for a fact, and so I guess what I'm saying is, even though we're next door and we may have to smell their smoke, we're okay with that. Just because they're good neighbors, and we don't see a problem with that. They shared their permit with us, I want to say about 3 months ago, and we're fully supportive of the permit and the process.
Does that conclude your remarks, Mr. Penry?
Yes.
Thank you very much. Are there any other people here tonight with us that wish to speak on this item that did not sign up?
May I add one thing real quickly? And I apologize, but the one neighbor that lives, I think it's the Parallax. No one lives in that house, and no one's lived in that house for years. So I'm not sure why they would have a complaint. So
What address?
It's immediately behind. I think it's called the Parallax House. I think that's what I heard. But no one actually lives in that house. It's a kind of a derelict house.
All right. We'll note that. Thank you.
Thank you. Yep.
All right.
I thought those people were
Board members.
Madam Chair.
I'm sorry.
Madam Chair.
Mr. Melnick?
Yes, I have a question for the applicant, or their agent,
Okay.
Ms. Riley. So my question is, what efforts were made to, see if this fireplace couldn't have been put 25 feet from the property line in the rear? Because I'm looking at the hand-drawn diagram, and it's in the midst. It's right next to, looks like the house location survey, and it's called, fireplace detail on the top of it. But I was doing some measurements, and it looked as though on either side of the patio, it could be 25 feet away. Like if you moved it, toward one side or the other, instead of into the very back of the patio toward the rear of the property. But I just was curious, if that was investigated, putting the fireplace in any location where it would comply, or if they just landed on this, and just wanted to do this application. So can you describe the efforts or the investigations done to try to comply?
Yes, Mr. Melnick, I think the Lanes or their landscape architect, Karen Barnes, would be well suited to answer this question about their considerations in the placement of the fireplace in the backyard and the various constraints back there.
All right, Ms. Barnes, are you with us?
Yes, I'm here. Hi, I'm Karen Barnes. I'm the landscape designer working with the Lanes on the project. We looked at every location of the backyard. It's pretty close. If you're 25 feet, you're really at the back door or the windows of the back of the house. You can't put it on the side. We were very limited in our location. So in considering all of those elements, we chose the location we did so as not to cut down any trees. We have beautiful mature trees on the property, and we didn't want to cut down any of those or get in the way of any of those with the fireplace. So we chose this location.
Colleagues, while we have Ms. Barnes here, are there any questions of Ms. Barnes specifically?
Madam Chair,
Mr. Owen?
I'm still not following your response because I'm looking at the parcel survey.
Yeah.
And it appears that the back of the brick patio is at least 29 feet, and in another spot 32.4 feet away from the rear property line. So it would seem that even placing the fireplace at the back of the 29 foot away portion of the patio would still be 15 or so feet away from the house.
It's a little confusing because this is a survey that the Lanes had before they did an addition on their house. So the dark line represents the addition and the patio is beyond that. So if you look at the hand-drawn, it's more clear on the hand-drawn application where it says back porch. You can see that if the back of the fireplace is 10 feet from the fence and you went 10
15 feet more over, you'd be on the back porch as it exists currently. So,
right. Well, it's a little unfortunate because the survey is not accurate. This hand drawing shows no dimensions from the rear lot line except the proposal. So we don't see any other. Oftentimes with a survey, we can see lots of lines that we could measure from, and here there's no measurement provided from the front of the fireplace to the back of the house, for example. And that would be very helpful to have.
the measurements on the back of the survey that you do have, the 29.7 and the 32.4 are the current back of the house. So those are accurate.
So what's the distance from the front of the fireplace to the back of the house?
I do not have that measurement right now, but if we subtract out 10.4 to the edge of the porch, I'm sorry, I'm not that able to do that math in my head, but
I believe
29 is, yeah.
I'm sorry, Ms. Barnes, could you, I didn't follow what you just said.
So if it's 29.7, we subtract out the 10.4, I end up with 19.3. So you can see if I added 15 more from that, I'd be putting the fireplace 4 feet from the porch.
I don't follow that number. 19.
It should be, I think the Lanes went out in their backyard and measured this. The fireplace should be 14 feet from the porch with its current placement.
Madam Chair?
Mr. Melnick.
What I was referring to is, there's more space on the areas where there isn't the back porch. On the sides of the patio, that's what I was referring to. Just, in these spaces where there is more space, I understand there's less space where the back porch is located according to this hand drawing. But I was looking at the other where there's significantly more space on either side, just to clarify what I meant.
So for example, where the words existing walls appear on top of the patio, would that be an example of what you're talking about, Mr. Mulner?
Yes.
Or off to the side where the steps are.
Yeah.
In that corner.
Working with the side setbacks and the vegetation, I mean, if you're coming back, the existing wall is approximately 10 feet, some point a little greater. And if you have to be 25 feet away from that, you're really in the middle of their patio. You see where the table is in the photo that you have in your attachment.
We really are going by the drawing, the hand drawing. We need to be all looking at the same document. So if you could refer to this hand drawing, we see steps and we see an existing wall and we see patio space.
Right.
So could you reframe your comments according to this drawing?
So what is the specific question, or why couldn't we put it on the left of the drawing?
Yeah, you have patio area in the corner between the steps and the existing wall.
Right. Well, you're running into the same problem. We'd still be 10 feet, maybe 12 feet from the back line if we went in the existing wall down there.
It would appear that you would be on a line with the back porch.
It appears that the back porch, the thing labeled back porch, is about 25 feet away from the wall. So if you go to the left of it, looks like there's by right room over by where the stairs are on the left-hand side, and potentially on the right-hand side, also where the stairs are on the right-hand side. That would be farther back than the porch is. Or that could be farther back than the porch is. All right. Well, I mean, Madam Chair, I guess I wonder if we've explored this as much as we can without more precise drawings.
Yeah, yeah, we do have a concern here because we need to be very precise. If we're going to look at any alternatives, and this drawing is not very, doesn't have all the dimensions here. if anybody else can put dimensions here, that would be helpful, but if not, we.
This is Ann Lane. I do have one thing that I want to mention. I think from what I understand you all are saying is that you are suggesting that perhaps we push it to the sides.
Mm-hmm.
And what I would just note that there are mature trees. If it is on either side, we will have to cut down trees to accommodate the fireplace.
So there are trees in the patio?
There are trees in the planting bed behind the retaining walls.
But not in the area that marked patio.
Well, there is if it were in the patio, the tree hangs over that area, so that we would have to cut down that tree.
Knowing the location of the trees, and is that the case on both sides, that you have trees in
the other area on the far end, if you are asking about the far end on the other side, there is a very large tree that actually rests on the Penry's property and our property, both of our properties. That is also a space where how you enter in our yard and walk along the side yard to step into the patio.
In your application, are there pictures of your backyard that we should be looking at?
There were pictures.
I don't think there were pictures in our backyard, of our backyard.
That's correct. We did not submit pictures of the backyard existing conditions. I will note, as far as any placement on the patio, if the fireplace were put anywhere on the patio, either on the left or the right, the existence of the fireplace and the associated seatings would impede the lane's ability to enter and exit down those stairs there. Because of the socially distanced seating, it's going to require a lot of space, and they'd be walking right into it on their back steps. And that is why they decided to place it outside of the patio area.
So in this hand drawing, there is a rectangle that says proposed fireplace. Is that the footprint of the fireplace?
Yes, it is.
That looks pretty small compared to the patio area.
It's I believe the dimension is 6 feet wide and 3 feet deep, excluding the hearth.
It's almost 20 square feet of footprint.
Yeah, I'm just going by what's on the drawing here. It's a fairly small rectangle that looks like could fit in a lot of different places in the by right area.
Madam Chair,
Mr. Owen?
when we're finished with this line of inquiry, I have some questions for staff.
Any other questions for the applicant's architect? So what we were doing was right now just talking about options for the placement. There probably are some other questions, but if there are no more questions about placement options, let's move to Mr. Owen's question.
I just think if I could, Madam Chair, I'd just like to make a comment that may help to clarify. It's hard not being there and able to point to something. It's such a visual medium. But if you were talking about the large expanse that says patio to the left of the proposed fireplace, that is where the covered pergola and eating area are on the lane's patio. So it would be difficult to place a fireplace in the middle of that area and not have to take down their existing pergola. And then on the other side, it's a little bit narrower and it's a walkway around to the side of the house. So you'd be in essence placing the patio in the middle of a space. So it just presents more difficulties than appear. It appears on the drawing like it's a big blank space, but it would really be in the middle of everywhere you wanted to walk or sit on the patio.
So there are structures here that in their backyard that aren't shown on this drawing.
I have a picture on my screen on Microsoft Teams that I'm looking at you've put up, that you guys have put up, that shows the placement. So I don't know if everybody is looking at the same. Sorry.
We're
I
looking
can
at
see the,
the
I can
sketch.
see the photograph.
But on the sketch that you presented, there is a pergola. There's other structures here that aren't
Yes.
shown on the sketch.
Yes, correct. It's in photos that is in a presentation that's on the screen right now.
Madam Chair, on the staff screen next to the timer, I currently see a photograph labeled 1036 26th Road South Wayne House, and it shows a pergola
Yeah,
and
I
a
see it.
dining table.
That's on the left side, okay?
Correct. Correct. In the photo that's appearing right now, where the bush is, where the wall makes a jog, that's the location of the proposed fireplace, which is the largest portion of the, yes, correct. Whoever is pointing to it, that's exactly right. And then to the right, you can see the patio narrows a bit, and it is also an exit or egress from the patio to the side yard where they have a lot of utilities and trash and things that are commonly used. So
can we go back to the previous picture, please? Thank you. So the other question we were asking was, what about the area at the far side of this picture, in the very back of this picture, past where the grill is? Oh, interesting that where the grill is now.
yes.
So what would prevent the fireplace from being located there?
Well, generally, I don't like to build a fireplace so close to the house, blocking the windows. It would be in front of the windows and very close to the house.
And then what if it were farther away from the photographer than that location?
Well, then you're really in the middle of the walkway to the side and in the middle of the patio, so it would make it difficult to sit around it. Like, you have to have enough room to, and this is not even a COVID thing, just generally to have furniture for people to enjoy and sit around a fireplace. You need to have enough room to create your seating, so there wasn't enough room right there. And aesthetically, for the lanes, we were trying to present something that would look good from the house and be an addition, an attractive element in their yard, and not just a functional element that they could enjoy with friends, but something that looked good from inside and outside the house. So if you're putting it in the middle of the patio, that really wasn't something we wanted to consider.
And Karen, if I can offer something, this is Scott Lane. I think the challenge of having it, actually, when the whole COVID thing happened, this was when we decided that we needed to do something in our backyard because we had a very small patio at that time and we couldn't push the chairs apart. And so in order to move from the street to our backyard, we decided to build a larger patio, which is in part why we decided to have the fireplace to extend the seasons. But I think by having it in the middle like that, in essence, our patio is wide and narrow. And so by having it in the middle allows more chairs to be placed in an area that would allow us to be able to stay outside and be there during the fall and during the spring. Once you get down to the end of the yard, it gets very skinny. And so the number of chairs that we can use in that area really become limited. So I just wanted to point that out. And as you go out those stairs, you do go to the side yard where you have the and so forth.
Thank you. Ms. Barnes, were you the person who specified the fireplace?
Yes.
Can you tell me, in the original presentation, I think it was Ms. Riley said that the purpose of the 12-foot smokestack was to dissipate smoke? Is that correct?
Well, the purpose of having it at 12 feet is for aesthetic reasons. It's a good proportion. It looks nice and it functions. It does remove the smoke and take it farther away. I think it's perfectly acceptable and customary in Arlington to burn wood in your backyard. You can either buy a fire pit from front gate or build one. And I think, you know, everywhere smoke is going to be generated. I think she was just trying to present that if you have a low fire pit that's on the ground, wood burning, your smoke is going to be lower. And if it's higher, then the smoke is going to dissipate into the air. I have built over 20 of these fireplaces. I've never had any complaints from anyone. We've never had any fires anywhere at anybody's house, and in many jurisdictions and in many more congested locations with closer trees and buildings. So I don't anticipate that being a problem based on my experience in the industry.
So the purpose, having a lower chimney, you would be concerned that there would be too much smoke on the patio?
There would be more smoke, but it generally isn't a problem. It's definitely the specifications and the engineering push the smoke up and out the chimney. I think Ms. Riley was just trying to point out that the smoke would be higher and therefore less likely to enter anybody's yard.
Madam Chair?
Mr. Melnick.
So, you know, in reference to all the issues that we've heard, you know, the smoke, sparks, you know, all this sort of thing, and then we heard the neighbor state that they had proposed natural gas, you know, something other than wood burning. And has that been considered? Because I know there's fire pits, you know, there's propane, you know, there's natural gas, you know, some are quite beautiful. But is there a reason why that, you know, wasn't done, considered in light of these complaints?
I can answer that. We did speak with the Hopkins and we listened to their concerns, and we actually agreed to look into the possibility of converting the proposed fireplace to natural gas. The estimated costs to do that were in the $10,000 range, not including any cost yet to be quantified. And one of the things that was most difficult was the fact that to run the gas line, we would have to remove, disturb, or dig up the newly laid flagstone patio in an effort to lay those gas lines, and then those stones would need to be replaced and relaid. So given the cost and the disruption, it was just something that we weren't willing to entertain.
Thank you.
Mr. Owen, I know you're waiting to ask some questions of staff. Why don't you?
It's fine. Mr. Melnick was on a roll, and that was all very helpful information. So if there's other things in that line, I can wait.
We can circle back.
Okay. Mr. Rissy, the staff report offers comparisons to the parcels that have other parcels that have both accessory structures and accessory buildings that are close to rear lot lines. However, the rules for accessory structures and accessory buildings are different. Accessory buildings may be closer to rear lot lines, than accessory structures. The applicant's statement mentions this characteristic of the zoning ordinance as well. This is indeed a curious feature of the zoning ordinance. What is the policy rationale? Why does the county board require accessory structures to be 4 to 10 feet away from certain property lines, but allows generally larger accessory buildings to be a mere 1 foot away? In other words, why did the county board think it was important to require a BZA use permit for a fireplace within 1 foot of a property line, but not to require a BZA use permit for a garage within 1 foot of a property line?
To answer that, I'll say that we had a very similar question for another wood burning structure at our last meeting, and we gave a pretty extensive kind of history of the situation. We don't have clear policy guidance here. This requirement essentially has been this disparity has been part of the zoning ordinance since it was set in 1950. At that time, there were only certain structures that were allowed to have reduced encroachments, and they were for parking. So it was only parking related activities. Over time, it's been extended to any accessory building because the structures for parking, most commonly garages, are all accessory buildings. But it's never been extended uniformly to accessory structures. So we don't really have a clear policy reason why we have a allowable encroachment up to 1 foot for accessory buildings, but not accessory structures. But we do have, some idea that this isn't a new problem. This isn't a new change. This has been something that's been part of the zoning ordinance for the last 70 years.
Thank you, Mr. Rissy. An additional question for Mr. Rissy. The staff report asserts that this proposal would not adversely affect the health or safety of persons residing in the neighborhood, but the rear neighbor takes a contrary view and asserts that the proposal would adversely affect their health and safety. What factors did the staff consider in making this determination?
So we looked at it broadly from a zoning perspective. Zoning is here to separate different uses and prevent noxious uses from being too close to others. This isn't a primary use. It isn't something that the zoning ordinance prescribes a specific setback for. This is an accessory structure that is actually not uncommon in residential areas. As mentioned by the applicants and some of the speakers tonight, there are other accessory structures similar, such as barbecue pits, that because they're mobile really don't have any required setback from the property line.
And then next, the staff report asserts that the proposal would not be detrimental to the public welfare or injurious to property or improvements in the neighborhood, but the rear neighbor takes a contrary view and asserts that the proposal would be detrimental to the public welfare and injurious to their property and improvements. What factors did the staff consider in making this determination?
I would say it's the same factors we considered for your last question. We're really looking from a zoning perspective about separation of uses. This is an accessory use, which is not uncommon for residential areas.
Thank you, Mr. Rissy.
All right, thank you. All right, any other questions of the applicant or any of the speakers?
Madam Chairman.
Ms. Freshman.
I don't have a question per se. I would just like to observe that we've been working off a drawing that really could have been much more helpful and expedited the discussion immensely if it had shown where the existing furniture is, so that looking at a photo such as we are, we would be able to see exactly where that table is on this drawing and where the seating area is. I'm surmising where it is because I'm surmising the column that I see on the right of the photo is part of the back porch, but I'm not entirely clear on that. And we've also discussed the existing trees which are trying to preserve. Would have been helpful for them to just be shown as well. So I am generally support the application, but I think that it would have been extremely helpful if we had had an exhibit that had just enough information for us to understand the proposal more clearly and address the alternative sites and the constraints for them. That is the kind of exhibit we quite often have, and it would probably have saved us 20 minutes of discussion.
Thank you, Ms. Freshman. Any other questions or comments of either the applicant or speakers?
Madam Chair.
Mr. Melnick.
Yes, so I'm in agreement about the drawing, the need for detail. But for me, this clearly seems to fall into the requirement, the question that we have to consider: would the proposal be detrimental to the public welfare, injurious to property or improvements in the neighborhood? I don't think there's been sufficient evidence to, prove that it wouldn't. I mean, I've heard some very persuasive arguments, about possible smoke, if this thing is as close as it's going to be. And so, I think, I'm inclined to vote against it. And so I don't know if a deferral would be helpful for the parties, like whether anything else could be done, to investigate any possible relocation, any possible alternatives. But I'm thinking, with the board discussing this, maybe we could give them an idea that maybe it would be fruitful, to go back and discuss this again instead of having us take a vote on how the other board members feel. But I think it's very persuasive what I've heard about possible injury from the smoke in light of the topography and the closeness of the fireplace to the line. That's where I stand.
Thank you, Mr. Melnick. The 12-foot chimney is of concern to me, given that really is taking smoke away from the applicant and putting it up higher in the air, which just happens to be somewhat level with the backyard neighbor.
Madam Chair.
Mr. Owen?
I basically agree with Mr. Melnick's remarks. The applicant has the burden of showing that the proposal would not adversely affect the health or safety of persons in the neighborhood or be detrimental to public welfare or injurious to property. And the neighbor has presented voluminous evidence to the contrary. And mainly what I'm hearing in favor of this is, well, there's other kinds of fires allowed. And since that's allowed, this must be okay. But that's not our charge. The Board of Zoning Appeals has to find that the thing we're approving is not injurious to health and safety, even if other similar things would be. The similarity examination is under a different prong of our analysis. We have to compare like properties for footprint and placement. And there, I think the applicant has met their burden. If they were proposing a table or something, and not look a brick table, I think that would be similar. But that comparison is not applicable to the health and safety and the public welfare analysis. The other thing I would say is that the government has been in the business of regulating smoke traveling from one residential property to another. I looked it up this week. Courts have been doing that for over 400 years in our Anglo-American tradition. The earliest case I could easily find about noxious odors from a neighboring property was from 1610. So I do feel like this is well within the center of what the county board probably meant when they put these criteria in here, that if someone was going to have something that pollutes the air too close to the neighbors, that they would encounter the polluted air, we're not supposed to approve it. So I think it actually seems pretty clear cut. This is despite the fact that there's other things that are allowed to burn in this location. I think we're required to say, no, you can't build a wood burning fireplace in this location. Now, would I be open to, a use permit with a 24.5 foot encroachment or a 23.5 foot encroachment to allow them to turn a corner without ripping up a tree or something? Maybe. But I think the basic proposal here, which, is well thought out from the standpoint of the aesthetics for the owner, doesn't meet the health and safety or public welfare criteria that we have to find. even if some people would say it's slight, I mean, the 1610 case, the neighbor who wanted to build, in that case, a pigsty said, well, the neighbor shouldn't have so sensitive a nose. And the court found no, you just can't injure your neighbor that way, sensitive or not.
All right. We have differing views on whether this is approvable. Often in these cases, we ask the applicant if they would like more time to reconsider their application or to develop other evidence for us to consider. I guess, should I be addressing Ms. Riley in this case?
Yes, Madam Chair. We would like the opportunity to defer this case to the next BZA hearing for an opportunity to do further research and present you with better exhibits and more explanation as to the placement and design of the fireplace.
Right. I think we are deferring now to at least December. Ms. Freshman, go ahead.
Yes, I was going to say December.
December. All right. Well, that's helpful. Thank you, Ms. Riley. When we do a deferral, we often, give you additional guidance that might help you come up with a successful application. So if there's any additional comments that we would like to give the applicant as to what we might look for when they return.
Madam Chair.
Mr. Owen?
I would be open to entertaining a safer structure than what is currently proposed in a similar location, or the same structure or the same hazard in a location farther from the neighbors. But what I would not find very helpful is 40 pages of why it's okay to put smoke in the neighbor's yard in the current location. I think that would be a waste of time.
All right, that's one comment.
Madam Chair.
Mr. Melnick?
So I'd like to echo Mr. Owen's comment. I feel exactly the same way. And I think, as we typically do in a case like this where there's neighbor complaints, is for them to continue to try to work with the neighbor to come up with some solution. Just along the lines that Mr. Owen said. Just reach out, keep in touch with them, communicate with them, and continue to see if there's some common ground. I think that's always a plus. At least communication.
Definitely, Mr. Melnick, I agree. When the parties can speak among themselves and come to a mutually agreeable solution, it avoids us having to make an up or down decision that disappoints one or the other party.
Yeah, and Madam Chair, I have one more comment.
Mr. Melnick.
I like to say, what Mr. Owen says a lot in other meetings is that the neighbors don't have a veto power, over applications. And that's important for applicants to remember. So we're simply, just in light of the objections that we're taking seriously, that's the reason for the communication and the efforts to try to agree. But, I just wanted to stress the whole thing about neighbors not having a veto power, per se.
That is correct. Any other guidance that we're offering at this time? I think
Madam Chair, I have a quick question about the next meeting. I believe Ms. Freshman said the next one was in December. I just wanted to know why that's the next one and not November. Is it notice related?
Our schedule is full for November.
Okay, thank you.
Fuller than we'd like, I think. So we are looking for more interaction with the neighbors. reconsideration of the structure or the location, clearer diagrams as to what is the existing condition versus the proposed condition.
And Madam Chair, when you say re-examination of the structure, I understand that to include re-examination of the nature of the pollution to be expected from the structure.
All right, re-examination of the nature of the pollution. That was certainly part of the structure.
Which means, for example, use of natural gas or other fuel.
Okay. All right. We have an agreement from the applicant to defer. Do I have a motion?
Madam?
Ms. Freshman?
I move the Board of Zoning Appeals defer use permit V-11584-20-UP1 to the December 2020 BZA meeting for the purposes so stated in the discussion.
Is there a second? Mr. Melnick, seconded by Mr. Melnick. Any further discussion?
It's December 16th, just to complete the date.
All right, December 16th. Any further discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
And chair votes aye. So the motion to defer to the December 16th, 2020 BZA hearing carries. We will see everyone back in December. Thank you, everyone.
Thank you.
Thank you very much.
Thank you, Madam Chair.
Much.
Thank you.
Mr. Rissy, will you call the next item?
The next item is case number V-11585-20-UP-1. It is a use permit request by John and Lindsay Arthurs, the owners, to permit street setbacks of 12.9 feet to the wall, 12.1 feet to the eave instead of 25 feet to the wall, 21 feet to the building eave as required, 10.6 feet to the entry eave instead of 21 feet is required, both from South Lorton Street. To permit a right side setback of 7.9 feet to the wall instead of 10 feet is required. To get an aggregate side setback of 15.9 feet instead of 18 feet is required. And to permit a rear setback of 14.1 feet to the rear stoop instead of 21 feet as required. Regarding two-story front addition with entry eave and rear stoop in the R27 zoning district on the premise known as 1927 South Lorton Street. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions.
Thank you, Mr. Rizzi. Is there any questions for staff? All right. Is John or Lindsay Arthurs with us tonight?
Yes, we are here.
All right, I hear you.
Hopefully you can see us
too. I don't see you, but I hear you, so you can go ahead.
We should be coming up pretty soon.
Okay.
Hi, my name is Lindsay Arthurs. This is my husband, John, and we appreciate everyone's time tonight to consider our use application. We are longtime residents of South Arlington and very much love our community. Our daughter started kindergarten this year, so we are very much tied here and happy to be here. I've been in the area for 16 years, so I like to consider myself a local, but you guys might not. My husband grew up in Arlington, so we were here for a long time. And I just wanted to say that our application stands for itself, and we're happy to answer any questions that you guys have tonight.
All right, thank you. Any questions for the applicant?
Madam Chair, I'll just make a comment that the applicant did really robust neighbor outreach, and that was very appreciated and helpful.
Yes.
Yes, it very much is. Any other questions for the applicant?
Madam Chair.
I have one. Were you going to move?
I was, so I'll wait for you.
Very quick question. There was just something on your elevation I didn't understand. What is the new bug mesh screen? What's behind it?
Plug mesh, what page is that on?
It's on the proposed west elevation.
That's a very good question.
It's not, if you don't know the answer, that's fine. I just had not ever seen that on an application. I wondered what was behind it.
Yeah, that's a really good question. I feel like I've looked at these a gazillion times and I don't know that I could tell you what plug mesh is actually.
Because that's your front door right there, right? Are those windows at that elevation?
So the front door will be below grade.
Right, and then to the left of that are these meshes.
Oh, you know what, they were originally it was going to be just screens, and then there was a miscommunication between the architect and us, and we want them to be actual windows, so the whole room will be closed in and not, they thought it was going to be like a screened in room, but we wanted it to be a fully functioning, heated, cooled room. So it looks like it's mesh, but now they're really going to be windows.
Okay. All right, thank you. Mr. Owen?
Madam Chair, I move that the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11585-20-EP-1, subject to the conditions listed.
Second.
Seconded by, motion made by Mr. Owen, seconded by Ms. Freshman. Is there any further discussion?
You were probably worried after that fireplace took an hour. This is going to be this easy, right?
100%.
At least you didn't have to wait in the courthouse.
We've had to do that for our neighbors before, so yes, we're very happy this is virtual. Thank you, guys.
All right. It sounds like there's no more discussion. I'll call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion granting the use permit carries. Good luck with your project.
Thank you very much.
Thank you.
All right, take care. Mr. Rissy, next item, please.
Next item is case number V-11586-20-UP-1. It is a use permit request by Avery and Richard Reese, the owners, to permit a street setback of 19.2 feet to the porch, 18.6 feet to the porch eve from Henderson Road instead of 21 feet to the porch, 19.5 feet to the porch eve as required, regarding a one-story front porch addition in the R6 zoning district on the premise known as 4629 Henderson Road. Staff recommends that the board adopt the attached proposed resolution granting the use permit request with conditions. And I'd like you to please note that there is supplemental material for this case that came in after the application packet was assembled and printed. It's a couple of additional letters of support from the applicant's neighbors.
Thank you, Mr. Rissy. Any questions for staff? All right. Is Avery and or Richard Reese with us tonight?
Yes, I hope you can hear us okay, and we're sharing our video as well.
All right. We hear you. Great. You may proceed. The video will come up, I guess, in due course.
Okay. I just wanted to read a brief statement. So my name is Richard. This is my wife, Avery. We're the Reeses. We moved into our home on Henderson Road in October of 2019 after purchasing it from the previous resident that we learned inherited it from her parents. So it's been in the same family for a long time. We intend to stay in this home in Arlington for a long time as well and to raise our family here. Gathering support from our adjacent neighbors was a unique challenge in times of social distancing, and this process provided a great reason to share contact info. We're happy to have support from all of our adjacent neighbors for this project. We also have to report that we're now on a first name basis with saved phone numbers for all of our neighbors. This is actually a net benefit for us to meet our neighbors. Regarding the goals for the project itself, it's intended to give a new update to a house with great bones, but could use a little love. And our setback request does not seem to be out of line with this neighborhood. Regarding the front porch itself, we reached out to the Arlington Forest Civic Association. They said that they don't really endorse projects like this, but they do actually list front porches as a defining characteristic of homes in our neighborhood. We've reviewed the staff recommendations and proposed conditions, and I have to say we find them pretty agreeable to our project goal. So in the interest of the board's time, we want to make our statement brief, but we would be happy to answer any questions that you have for us.
Thank you, Mr. Reese. Any questions for the applicants?
Madam Chair,
Mr. Owen.
I would just say I especially appreciated the outreach to the church across the street. Sometimes applicants just blow right by institutional neighbors like that, and it was great that you did not and made sure to try to get their feedback as well. So thank you for doing that.
All right. Any other?
Madam Chair,
Mr. Melnick,
I'd like to make a motion.
please.
Okay, so in case V115860 UP1, I'd like to move that the Arlington County Board of Zoning Appeals grant the attached proposed resolution with the conditions as stated, in addition to the 3-year expiration condition that we've mentioned.
I'll second it.
Second. Motion made by Mr. Melnick, seconded by Ms. Clark. Any further discussions? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. Motion granting the use permit carries 5-0. Good luck with your project, Mr. and Mrs. Reese.
Thank you.
All right. Mr. Rissy, I believe this is the last item.
The last item on the agenda, Madam Chair, that is correct. That is case number V-11587-20-UP-2. It is the use permit request by Jeremy Meltzer and Courtney Collard Meltzer, the owners, to permit a rear setback of 16 feet to the wall, 15.5 feet to the eve from the rear property line, instead of 25 feet to the wall, 21 feet to the eve as required, regarding a 2-story addition in the R6 zoning district on the premise known as 5940 2nd Street North. Staff recommends the board adopt the attached proposed resolution granting the use permit request with conditions.
Any questions of staff? Are the Meltzers here with us tonight?
We are. Good evening.
Good evening.
My name is Jeremy Meltzer. This is my wife, Courtney Collard Meltzer. We're the last on the agenda we recognize, so we'll be brief, but just thank you for reviewing our case. We think that the application kind of speaks for itself in our desire to stay in our home with a modest addition. We've done our neighborhood outreach and gotten good support from neighbors, as well as the Boulevard Manor Civic Association, which Courtney has been a past board member of the association. So it just kind of brings some unique perspective to us of concern about the neighborhood. We're joined tonight by our contractor, Steve Tinter from Cook Brothers, if there's any more technical questions, and we appreciate your consideration.
Thank you very much. Any questions for the applicant?
Madam Chair,
Mr. Owen?
I did notice that you had pretty thorough neighbor outreach, but I could not find the feedback from the rear neighbor at 5929 First Street North. Did I miss it, or did you get written feedback from that neighbor, or what was the outreach to that neighbor?
They did not submit written feedback. We contacted them on August 12th. We sent emails to both the husband and wife. Kind of took their non-responses as ambivalence. Do have a dog over there, and with coronavirus, we just weren't particularly comfortable knocking on their door, given we don't have regular interaction with them. We were able to verify that their emails were correct because we actually ended up hiring their son a few days later to cut our grass when we were out of town. We copied his parents on that email, so we do believe it was received.
Okay. I'm curious because they're downhill from you, and they have this really big tree that's pretty close to your property, your shared property line. And so I hope that there's I hope that you're taking care to address any water runoff that may be increased by the greater impervious area in this part of your yard. Do you have a sense of how you're going to handle the gutters and water effluent from the roof there?
We've thought about it. We've talked to the contractor about it. There's also a very similar tree at the house directly behind us at 5933 First Street. Right? It's also large and about the same distance off our rear property line. We don't notice any current pooling or history of water issues. There was an expansion done by prior owners of our home, kind of more across from that tree 8 to 9 years ago to enclose a porch. And again, that hadn't resulted in any water issues either.
Okay. Well, I would just, since you do have the rear neighbor who has the most abutting land, on board, I feel somewhat comfortable with this, but I would just say, out of a sense of neighborliness, I hope you will take care not to put a drain spout that goes directly into the, your neighbor's yards. Consider a French drain or just be on the lookout for that. I'm hoping that the foundation of what you're building would not affect the tree's roots. And the water might help, right? So trees go well with a lot of water, so there's some balance there.
Sure.
But I would just say it may be the case that your neighbor is actually not really thrilled about this, and that may be the reason that they didn't respond. And so instead of having a neighbor here complaining and asking for a denial or something like that, maybe they just were quiet. Sometimes that's what happens. And so I would just take that into consideration as you're finishing the project, just to kind of look out for them and don't make them regret that they didn't come here objecting.
Absolutely. Understood.
Thank you, Mr. Owen. Any other questions for the applicant? The discussions with us?
Motion?
Ms. Freshman?
I move the Board of Zoning Appeals approve the attached proposed resolution approving use permit V-11587-20-UP2, subject to the conditions listed and with a 3-year time limit.
I'll second it.
Motion made by Ms. Freshman, seconded by Ms. Clark. Any additional discussion? I will call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. The motion to grant the use permit carries 5-0. Good luck with your project.
Thank you.
Thank you.
All right, and good night.
Good night.
So now we're back to the monthly schedule.
We are back to the monthly schedule. Speaking of schedule, I don't know if I sent this to, I think I sent it to everybody. Staff had mentioned that they have no objection and have actually a preference for meeting in January, which has not been our pattern. I guess at the November meeting, we might, Mr. Izzy, would you be able to bring a draft schedule to us?
I'll try to prepare something by November, yes.
Because you'll probably need to know if we're meeting in January, right?
Yeah, we've placed the January deadline or the January meeting and deadlines on the website. So if you want to not meet in January, let me know so we can remove those meeting dates and deadlines.
So folks, are we okay with January? Theoretically, we'll adopt a schedule when we have one before us, but for Mr. Rissy's planning purposes?
Madam Chair?
Mr. Owen?
I'm fine with having a normal meeting in January, but I do think that we benefit from having a organizational meeting once or twice a year. And I think that when we try to cram that in with cases, it creates stress. So I'm presuming that having a regular hearing meeting in January will not preclude us from at some appropriate time having a an organizational meeting as well.
Good. Ms. Freshman?
Stephen, do you have a date for January?
We have one on the website. Let me pull it up.
It's easier to just ask you. I appreciate that. I agree that maybe if we have a January meeting, we might also have an organizational discussion at some point on a different night from the whatever hearing we might have. And do we have an idea of how long we're going to be blessed with virtual meetings?
That I really don't have an answer to. I would say it doesn't look like we're getting away from them anytime soon, but that's probably the best guidance I could give to that right now. I will say the January date is January 13th.
Great, thank you.
Just so folks know, we have January 13th, February 10th, and March 10th as our tentative dates already rolling into 2021.
Okay, great, thank you.
All right. So I'll get back with you, Mr. Rizzi, on some potential dates for an org meeting.
Okay.
All right, and if you could bring us a schedule for us to look at in November, then we can adopt it and you can move forward with certainty.
I'll put something together for November with the assumption right now that things are going to be digital and we don't have to worry about conflicts with rooms. I would say November is generally kind of early for us because we need to get the county board room calendar.
That is true. Yeah, that is
but
true.
I'll put together just what our ideal calendar for 2021 would be, I would say.
Okay.
And if everything's digital, then we just go with those dates. And
or we choose to adopt 6 months worth of schedules or something like that. That's a good point about checking board.
Yeah, if it's possible to book the boardroom on a contingent basis, to me, I think March would be the first time I would bet that we would even consider using it. If a vaccine came out tomorrow,
I wouldn't take it.
Be first in February. What?
I wouldn't take it until Fauci tells me I'm not taking it.
So,
I'm just saying.
I don't think Judy's going to get a vaccine before February.
And honestly, Stephen, no, yeah, right. And Stephen, I would just say that I think that long term, given how long it may be until everyone has therapeutics and vaccines, which could easily be another year or more, I think we should at least have the option to participate virtually. And I don't know what the governor thinks about all that and what the rules are, but there are going to be people like me who are going to be hesitant to return to the courthouse even when we're allowed to.
Yeah.
And I would hate to have to leave the board just because I felt uncomfortable.
In that vein, I happened to have a conversation with an elected official, and there is some consideration of whether or not making virtual meetings a permanent option is being considered. There's some difficulty in that. There's pros and cons to that. I don't think there's agreement yet, but there are groups that have found having that virtual option to be very helpful. On the other hand, there's the equity issue of access to virtual that may not make it suitable for all meetings. And so they're weighing some options, but it is being considered as a possible, let's say, more permanent addition to meeting rules.
Yes, and I've been in at least a half a dozen meetings a week at this point, even when I was out of town. And it's much more democratic with a small d. There's been much better participation. People that don't have to worry about babysitters or weather or, any of the usual concerns. And so I believe that may be, I hope that will be taken seriously, because I think it's given us an opportunity, as difficult as these times are, to revisit how we do things just because we've always done them the same way.
Mm-hmm.
I don't disagree with anything Judy said about our hopes, but there's also the reality that we don't call all the shots here on the open meeting law.
I understand.
And so it may be possible, I think it is quite possible that sometime in 2021, probably not, certainly not February, probably not March, but maybe by October or December of 2021, that it may come that soon that it is both safe and required that we meet in person, despite what we might want. So I think the point is, for the later meetings in the year, it would make sense for Mr. Rissy to still look at the room availability, just to, have a chit in, and
Sure.
not presume that we won't be in a room, at least by the time we get to the end of the year.
Yeah, we should investigate that, because at one point it seemed that as long as 3 people are in a room, 2 people can join virtually,
correct.
and that and the public can join virtually, even
Yes.
under the old rules.
Yes.
So we have a variety of options, and one would be to rotate people in to meetings who felt comfortable, or but I don't know if the legislature is going to take this up in 2021 for sure, but there is some discussion that this has been a great experiment, and we've learned some things, and maybe we can change the way we do things.
I would still volunteer to drop off cookies.
Well, that makes the difference for me, Judy.
Socially distanced cookies. Okay, we have one more item on our agenda, and that's to approve the minutes from the September 16th meeting.
I will move approval of the minutes of the BZA minutes of September 16, 2020.
Do we have a second?
I'll second.
All right. Motion's been made by Ms. Freshman, seconded by Ms. Snell. All in favor? Call the roll. Mr. Owen?
Aye.
Ms. Freshman?
Aye.
Mr. Melnick?
Aye.
Ms. Clark?
Aye.
Chair votes aye. 5-0. Yay! Portia, did you get my note about the BZA hearing or BZA program being rescheduled to the 29th and 30th?
Yes, I did.
When you have a chance, let me look at your schedule and see if that might work for you.
Yeah, I just checked it. It works for me.
So go ahead and enroll you.
Yes.
Okay, great. Mr. Rizzi.
On that note, if we can, we being the zoning division, pay for the training rather than trying to reimburse, I think that is currently going to work easier. Obviously, we will reimburse those who have already spent their money, but there's a process to set you up as vendors that we won't have to go through if we just pay ourselves.
I think at least 3 people have already paid.
Yes, we'll still reimburse you. I'm just saying it's more process to reimburse than it is for us just to do it ourselves, it seems.
So do you want to enroll Ms. Clark?
If she's, yeah. I think that would be the preferable option.
So what, do you need anything from her to do that?
I'll contact her to figure out if I need any contact information or what it is.
Okay, all right.
Okay.
All right, we're done. Thank you, Judy.